they want to climb.
Serial number 18.
18 from supplementaries. कल जो mention किए थे आज supply पर आया हुआ है.
Mentioned that the menu.
रखवाए थे.
Yes, what do you say?
Ma'am, leadership, we were not informed by them that they will be mentioning the matter.
They informed you after mentioning?
Yes, they informed us today only.
Yesterday evening sir को text written message inform की. या शाम हो गया था court और
क्या करना?
Leadership, it may be posted for 13 or 14 final disposal. 13 or 14 as a legal course permit.
18, right?
14 or 15 any day.
Serial number
18.
18. Yes.
With the consent of the learned counsel for the parties, post this case for final disposal. Repeat on the second half of this. Parents of the
Previous rates. LWT purchase charge and
on the 15th. We'll do it on 15th.
आप अपना पीरियड From this supplementary list, under heading for to be mentioned, item 1, 2nd April 131 of 2026.
Why is it listed?
Date of posting.
SC 131 of 2006. This case has been listed at the instance of the office in order dated 3/7/26 at paragraph 4. The next date of listing has been inadvertently typed as 17/7/24 instead of 17/7/26. Accordingly, the order dated 3/7/26 is monitored. The next date of listing in paragraph 4 is directed to be made as 17/7/26 instead of 17/7/24. The office will carry out necessary corrections.
Under heading for final disposal, item 2, WPC 6961 of 2016 along with item 3 to
I was told that Tata Steel matters at the
Yes, because all the facilities are related to Tata Steel. So if the Tata Steel has
some merit or the others can deserve some concept.
yes,
There are 3 cases of Tata Steel. Serial number 9, serial number 11,
9, 11
and number 3, 9, and 11. Now 3 is for the period 2017-2020.
17,
As in 17, 18, 18, 19,
That's it.
19.
9,
9 is for the period 2021-22. August 21 to August 22.
August.
Yes, August. I am. Sorry, this is 9 is also August 20 to August 21. 9 is August 20 to August 21. Actually, 8 is
August 21. And this is 3 is 2017 to July 20.
August. From August
August
17
is
to
overlapping.
August 2 minutes, August 2020, and then from August 2020 to August 2021. 8th August. It's like a date there. From 8th August 17 to 7th August 2020, and then from 8th August 2020 to 7th August 2021.
Just
I have the notes, sir. Can I just ask?
yes, you have given the notes.
No, because I have prepared my letter has prepared individual notes. Why? And 2 can be disposed of like this in 1 minute. I have an answer to 2 questions, the last 2 cases. And you just have a look at the serial WPA 2536 is the case which will be argued for the longest time, probably must 10 minutes.
Serial number 3.
3. Right?
So we'll do that later.
We'll just have a look at that later.
9 and 11.
9 and 11, kindly have 9 is plus 2661. 9 is 2661.
Yes.
just have a period of, the period is 8/8/2020 in the first paragraph only you mentioned to 7/8/2021. Says similarly in the second case is 8/8/2021 to 7/8/2022. Now in these two, while we made an application of the exemption of the establishment for these years, in my application, which your lordships can find at page 97 of the first page, we had said that the covered employees are zero. As in no one below 21,000 works. But as a matter of caution, we had made this application that if someone comes in,
Yes.
exemption, one person comes in for that,
That's
similar is 2020, the next case, employees covered is zero. So though it was zero, they rejected it on merits. All these same grounds, their medical benefits are bad, sickness benefits are bad, disability benefits. And they said that क्योंकि आपके employees बहुत कम है 21,000 के नीचे, but whereas there's zero. So today, my lord, that periods are over. There is no demand for those people because no one above 21, below 21,000 joined Tata Steel during those two. So the discussion today will be academic. So your lordship, I think this is my submission. My lord, your lordship can dispose of by saying that since during the periods for which exemption is sought for, no person covered under the SI Act was working, and there is no demand by the SI. The issue has been rendered academic. Any observation made against me will not be used against me for any other proceeding, which will be decided on its own merits. I am only saying the observations errors will not be. It may not say that that case was dismissed. It also are the same grounds because the grounds are this. Because I can argue this, but it will be academic. Ultimately, nothing, no purpose will be solved.
where is the respondent?
Yes, Mr. Ashutosh Anand. So I think these two cases can be disposed of till Mr. Ashutosh Anand comes now.
Where have you stated that?
Yes. Kindly come to the application clause.
So this is 6961,
So हम ले लेते हैं 2661.
2661, sir. 2661 and
Page 9. I have just 2668.
2668.
इनका एक page 97 of 2661 kindly come.
Page 90.
7. The application itself.
Yes.
Kindly come to column number 5. Total number of persons covered under the wage ceiling up to 21,000 per month of the SI Act and the percentage of his total manpower. Total number of persons within the wage ceiling up to rupees 21,000, 0%, 0.00. Similarly, page 98 of the other information.
Yes.
Now there is no demand for these two papers because no employee joined me who was less than 20. So even if I argue not, it will just be for the sake of academy. So whatever terms your lordship thinks, may dispose of these two petitions.
The counsel for the petitioner is present. Nobody appears on behalf of the respondents. State is there? State is there? Or not there?
In item number 6 and 7, my lord, I am.
And for 3.
The
Three,
counsel for the
three.
3,
3 and so 3 number 3.
9 or 11 में है देवेश कृष्णा
9
and
and 11.
Sukma
They are not there, no? Nobody appears on behalf of the respondents. The learned counsel for the petitioner has submitted that, and these writ petitions have been filed for the following relief. The learned counsel for the petitioner in both these cases has submitted that for all practical purposes, these petitions have become infructuous, and the discussion with regard to claim of exemption of the petitioner for in these two petitions relating to the period from
8/8/2020
8/8/20 to 7/8/21 and 8/8/21 to 7/8/22 in WPL number 2661 of 2022 and WPL number 2668 of 2022 respectively is academic, and no demand has been raised for these periods. The learned counsel has referred to paragraph has referred to the application seeking exemption in the prescribed form as annexed in the petition itself, and has in particular referred to column number 5 and submits that it has been clearly mentioned that no such person is working in the petitioner company whose salary is up to rupees 21,000 per month, and therefore there is no coverage, and no employee is required to be given the benefit for this period.
ESI is also not raised any demand.
Yes, the respondent ESI has not raised any demand for this period. The learned counsel has submitted that the findings recorded with respect to the claim of exemption for this period in the impugn order may not prejudice the case of the petitioner so far as other periods are concerned. And since there is no demand, the writ petition has practically become infructuous.
Academically,
Has practically become academic. The learned counsel for the respondent ESIC does not dispute the FHS submissions. Considering the submissions, these two writ petition are disposed of as infructuous, as admittedly no demand has been raised for the period involved in this case. It is sufficient to observe that any findings with regard to claim of exemption during this period will have no bearing on the claim of exemption of other periods, which will be considered on merits, on their own merits, right?
yes,
So these two cases go. Correct?
that is the
उसका जो कॉलम 5 जो है एक में फ्लैट एक में पेज नंबर 97 एक में 98 है वो कॉलम को फाइंड आउट करना
If I was late, so perhaps.
हाँ very exactly.
I'm sorry.
You have said that you are not disputing this part.
it is when it's on record.
Yes, yes.
You see the-
Now it is 266.
Now it will be 2536 of 2020.
2566.
Syllabus.
Yes.
But Zodiac Lordships permit me, my friend, to start.
Ah, yes, yes,
Because
yes.
there's one matter which is.
No problem. Yes, start.
In 2536, there are two orders which we have challenged.
It is relating to which period?
First order also dated 12/3/2021 and issue 24 relates to the period runs from 8/8/2017 to 7/8/2018. And whereas the subsequent order dated 30/3/2021 and issue 25, it relates to
There
the
is a
period
page number in issue 24 and 23.
page 350 also. And at the top lordship will find the period for which it was applied for. And page 352 lordships, 353 lords.
353. Okay. Identical orders.
Identical orders, only one difference is there, mothers. In for the period 2017 to 2018, they have compared 5 benefits. While deciding that the benefits covered by ESI is superior to the benefits covered by Tata Steel. Whereas in 2018 to 20, they have compared only 4 benefits.
So which is the fifth one?
Fifth one lordship is the dependent benefits, Ashrit Lav, which they have not taken note of in the subsequent order.
Okay.
And lordship, if your lordship may kindly see the applications which we have filed for these periods. Those application lordship for the period 2017 to 18 is at page 107, annexure 13. since prior to this period, exemptions were granted to the Tata Steel from 2015 to 2017. So renewal application was filed. In other words, it was filed well within the time period. In other words, 3 months prior to the date when it was supposed to lapse. It was filed on 2/5/2017, and in other words, the period was 8/8/2017. So as per the statutory mandate, it was filed three months prior to the date of when it was about to expire. And in this application, actually the comparative chart was also annexed, which your lordship will find at page 125. Which dealt with altogether lordships around 10 to 12 benefits, which were not taken into account by the respondent state while deciding the exemption application. They only considered 4 to 5 benefits while deciding the application.
That's, so far as the rest of the benefits are concerned, they have no dispute on that.
But not those benefits have also been discussed by us as well as ESI in their reply.
No, I don't get it. You see, we will go only by the improved order. Whatever reasons has been assigned in the improved order, we will examine as to whether those reasons are correct or not.
I was only submitting order since the statute mandate that all the benefits have to be taken into consideration while deciding the
No, even if
comparative.
one benefit is not matching, it is enough to reject the application. Isn't it? All the benefits either should be matching or maybe better.
Lordships. It should be substantially similar.
Or some substantially similar. Merely because you have a very good department of heart, that does not mean that you may not have a department of lungs.
That is it.
So, and basically, so therefore, those benefits which you are giving may be better, but those have not been taken into consideration. The reason being that they accept that they are better.
Even lordships, the benefits which have been taken into consideration, our reply and our statement has not been considered by the respondent state, which we have stated so in the comparative chart. The benefits which we are providing, they have not taken note of that benefit while deciding that particular benefit.
Let us see one by one.
Lordships. The benefit.
Let us see the first reason. The first order has 5 reasons.
5 reasons.
Let us see.
Page 350.
3.
कर्मचारी राज्य बीमा अधिनियम 1948 की धारा 87-88 संगठित धारा 91(a) के अंतर्गत 8 अगस्त 2017 से 7 अगस्त 2018 तक के लिए मेसर्स टाटा स्टील लिमिटेड जमशेदपुर के विमुक्ति के आवेदन पत्र को निम्नलिखित आधारों पर अस्वीकृत किया है। पहला, चिकित्सा हित लाभ। कर्मचारी राज्य बीमा निगम द्वारा चिकित्सा हित लाभ पूरे भारतवर्ष में कभी भी के आधार पर उपलब्ध कराई जा सकती है। साथ ही कर्मचारी एवं उसके परिवार के आश्रित जन अपने सुविधा के अनुसार 2 चिकित्सालयों का चयन कर सकते हैं एवं आवश्यकता अनुसार ईएसआई अस्पताल एवं टाइप सुविधा द्वारा सेकेंडरी सुपर स्पेशलिटी हॉस्पिटल से इलाज पूरे भारतवर्ष में कहीं भी कराया जा सकता है। जबकि कंपनी द्वारा देय चिकित्सा सुविधा टाटा मीन्स हॉस्पिटल एवं उनके चिकित्सालयों के द्वारा प्रदान की जाती है। साथ ही आवश्यकता अनुसार रेफरल की सुविधा कुछ खास स्थानों के लिए भी उपलब्ध है। इस प्रकार कर्मचारी राज्य बीमा निगम द्वारा प्रदान की जा रही यह सुविधा कंपनी द्वारा प्रदान की जा रही सुविधा से बेहतर है। I can show the benefit which we had provided.
Which is the list of hospitals where a reference can be made.
That we have annexed, that is part of the record. That would be page number 370. It pertains to the data for the year 2017 to 20, where referral were made to these hospitals.
No, this is as on July 2021. How are we concerned with this?
Page 370.
As on July 2021.
Lordship, kindly see page 370 for a moment.
It is a part of this only.
It contains other page annexure 27 is part of this project. Annexure 27 page 364. Tata Main Hospital facts and figures.
360.
364.
Yes, 360.
Tata Main Hospital facts and figures.
From which is it? Is for which period?
Lordship will find it at page number 370. It provides the details of referral which were made for the year 2017, 18, 18, 19 and 19, 20.
370.
Lordships. 370. Services. These are the list of hospitals.
This is expenditure. These are the list of hospitals.
Lordships.
Right? Where are they?
But it's
And this list
some of
was
them are in Kolkata Lordship, Chennai, Hyderabad, Delhi, Mumbai. So they are different hospitals. Lordships. And these have also been mentioned in our comparative chart, which we had filed along with the
did you
exemption.
produce it before the authority?
Exemption application Lordship, the chart was
Did you produce it before the authority?
comparative chart was filed. Lordship.
I'm not talking about comparative.
This particular document
Yes.
includes that.
So
But it was
your
mentioned
chart
in
is
the.
of your chart is of no consequence.
No, it was. If you Lordship may kindly see the comparative chart, which was filed along with the exemption application. That Lordship will find.
What is this referral hospital wise? It means what?
That's the hospital where the patients, the employees are being referred by the TMH.
So on in the year 2017-18, these many persons were referred for treatment.
To these hospitals.
So where, how do we, this paper, who is certifying this? Yes, Tata Main Hospital.
But it is the documents relating to Tata Main Hospital, the records which they maintain regarding the treatment of the patient.
I don't know. This is not something which has been produced before them.
But the name of the hospitals has been mentioned in the comparative chart and the reply which is filed by the petition. Name of the hospitals are there, although this particular chart is not there.
Where is it mentioned?
That's page number 217 is our reply to the rejoinder filed by the ESI.
Let us see the rejoinder of this.
Rejoinder of ESI Lordships is at page 204. The comparative chart which they had filed also along with their rejoinder. 204. First one is the medical benefit. They have given the remarks the period benefit is provided by ESI. The fourth column. The first column is the detail of benefit.
So they say medical facilities provided in Tata Main Hospital dispensary to all the employees and
and their families, including their married daughters, till their first confinement. Homeopathy and Reiki treatment are available to employees free of cost. Mahatma Gandhi Arogya Bhavan and Jamshedpur caters to nature, cure, yoga and lifestyle management to the employees free of cost. Retired employees and spouses are given free medical treatment for life without any payment. And so far as the benefits given by the ESI is that in the second column, right, we may place these benefits which they are relying on.
Where is it?
The comprehensive medical benefit is provided to the insured person and their family members, which comprises preventive, promotive, curative, and rehabilitation services through its own network or through contractual arrangement with reputed institution in the government and private sectors. An insured person and his family members become entitled to medical care.
Do they provide any list? Do you provide any list?
We provided models at the bottom.
At the bottom, they have mentioned the name of the hospital. State Medical Commissioner ESI Corporation, Ranchi has entered into tie-up arrangement with following private medical institutions for providing different cashless medical facilities to the beneficiaries at Jamshedpur. They are, as mentioned, primary and secondary care, Mercy Hospital, so Medical Hospital, Purnima Nandale, Brahmanand Nagar, Jamshedpur, and thereafter super specialty treatment, Ramanand Narayan Hridayalaya, and Medica and Meditrina Hospital. Apart from these, they retired insured persons and their spouse with a minimum of 5 years service and disabled insured person and their spouse till the age of superannuation are also eligible for medical benefit against a monthly contribution of ₹10 per month. But
So,
they have
your
mentioned
list
the-
of hospitals are only
I
confined to
Jamshedpur.
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 This list is only with regard to Jamshedpur Hospital's tie-up.
So Jamshedpur hospital tied up.
This only.
What about they are giving?
Lordship, they gave a list of only one hospital at Jamshedpur, Tata Main Hospital. Lordship, this is 204.
No,
The
what?
third column. This their list. They gave a list of only hospital of Jamshedpur. So we confined our tie-up hospitals of Jamshedpur.
In our application, we have mentioned about the name of the other hospitals.
At 204, detail of benefit under employee
No.
scheme.
Where have you mentioned that you are tied up with Kolkata and
In the reply which they have mentioned, it is at page 217.
there is no end to it. No? 217.
217. It is part of the record which all the respondents gave. 217, Lordship, we have mentioned, if your Lordship may kindly see the third paragraph. Tata Steel provides treatment to its employee in their dependent relation in relation to above disease by referring to so and so hospitals across the country for specialized treatment.
So what about you? Your hospitals are confined only to Jamshedpur.
Because Lordship, at that particular time, they, as per this, page 204, they had stated about benefit only with regard to Jamshedpur. So we
From where
confined
do you say? From where do you say that they were only confining
at page
themselves?
204,
Yes, I am at page 204.
204, the third.
Yes.
Medical facilities providing Tata Main Hospital and dispensaries to all the employees and their family, including married daughters. So Tata Main Hospital, I think to my lords, that of homeopathy and Reiki treatments are available to employees free of cost at Mahatma Gandhi Arogya Bhavan at Jamshedpur.
So it is not talking about any treatment somewhere. Arogya Bhavan is a treatment.
Worships, what we perceive is because
And this yoga is a treatment.
worship we perceive
What
that
is this?
we perceive that since they are relying upon their hospital in Jamshedpur, we are only confining up to Jamshedpur.
From where do you get this? You have prepared a comparative chart.
Yeah.
From where do you pick up that this is what they have mentioned? Where is your application?
Application is at
Request for exemption, right?
page 107. Here also we have mentioned about the name of hospital. Page 108, if Lordship may kindly come. Page 108. Second page of the exemption application. We also the fourth paragraph, Lordship, the fifth paragraph rather. We also wish to emphasize that no facility as mentioned above has been curtailed, withdrawn, rather have been regularly improved.
108.
108.
The bottom, the manual Tata Steel also tied up with renowned hospitals of India like AIMS, Delhi, so and so, so and so.
It was filed prior to their filing of the comparative.
108.
Last paragraph. The last 4 or 5 lines. The management of Tata Steel has also tied up with many renowned hospitals of India like AIMS Delhi, CMC Vellore, Apollo Hospital, Medanta Hospital, AMRI Hospital, RNICS hospital, Calcutta.
So here is page 137. This is the application for the another period.
My lords. They were aware about the
Mine would be at
You were availing the benefit till the period prior to 2017.
2017. From 2014 to 17, we were availing the exemption benefits. And was prior to that, till the year 2010, from 2000 to 2010. For 10 years, we were granted exemption. Lordships, from 2010 to 13,
2000 to 2010, you were
Lordships.
granted exemption.
And
Then
thereafter,
2014 to
2007.
2007.
7/8/2007.
Just a moment. And then to 7/8/2017. 2017. What about this period, 2011 to
11 to 14, Lordships, 3 years,
10
Lordships.
to 13, 1, 5, 10 to 7, 8, 2013,
My lords, for these
1,
periods,
5, 10 to
7, 8, 13.
7, 8, 13.
This
What
was
happened?
rejected.
Lordship will be 38 and 14.
And what happened
For,
to this
for
order of
these period
rejection?
lordships, for 2010 to 13,
Hmm.
Lords, we have challenged the demand notice as well as the order along with the virus of section 91A of the PSI Act, which is pending before this honorable court for honorable DB1 notification.
So virus will be decided later, but it stands rejected.
Stands rejected.
If the virus goes in your favor, then all these exercise goes all together.
But because in
You will
that,
be completely out of that.
my lords, because in that particular my lords, order, it has been rejected only on the ground that you cannot be granted retrospective exemption. It has not been rejected on merit. So we have challenged that part as well as the virus of section 91.
That
Which is
new
meant-
provision which says
Well,
that it cannot be
It
granted.
will
retrospectively.
prospectively.
So that is not on merits but on.
Yeah.
So far as the facilities are concerned, there is no doubt.
There is no.
Yes, what do you
My
say?
lords, my reply 202, para 4. This was
Yes.
PSI scheme extends all the 3 levels of medical care to its beneficiaries, so and so, so and so. Primary care is provided through dispensary and private clinic. Secondary care is provided through ESI dispensary and ESI hospitals. Tertiary care is provided by entering into tie-up agreements with specialized private as well as government hospitals and diagnostic center all over India. Specialist services like heart surgery, neurosurgery, so and so, so and so are provided to the ESI
You have
without
not mentioned any institution.
the details of the institution are not
No,
mentioned.
nothing has been mentioned.
Just
What
a
do you mean?
statement is there that we are having
They
tie-up.
are having tie-up with AIMS.
But
They are having tie-up with the best of the hospitals.
the statement, like especially with regard to which hospital we are having tie-up, we have not mentioned.
They're absolutely vague. That is absolutely useless. You see, you might be having tie-up with all over India, but we know that the
Which are the best?
super specialist hospitals are only in the metros.
Definitely, my lords.
So this is not interesting. And how do you put in this comparative chart like this? That it is only yoga and all these things. How do you mention that?
This was from the application. This was picked up.
204,
204.
page number 204.
This-
Details of benefit under employee scheme.
Definitely, ma'am. This is under us, and the second comparative result is under the employer scheme.
Just a moment, we'll take the each reason, right?
And also, my lords, we provide my lords benefit to the retired employees as well. So that is the additional which we are providing.
We also provide.
That.
The learned counsel for the petitioner while assailing the reason for claim of rejection. Reason number 1, that is medical benefits.
Lordships.
Which is at item number 1 of the improved order with respect to both the years. Both the periods involved in this case. And I submitted that the super special treatment through tie-ups is being provided to numerous hospitals as mentioned in their application seeking exemption. He has referred to the application seeking exemption at page 107 of the writ petition and at page 137 of the writ petition, and has in particular referred to the second page of the application, in which the details have been given as under. The learned counsel submits that the petitioner has tie-ups with best of the hospitals of our country, which includes AIMS India, CNC Vellore, Apollo hospitals, MP hospitals, Medanta hospitals, and the treatment is available not only for the employees and their family but also their dependent relation and even the retired employees and their spouses. He submits that a rejoinder was filed to this application by ESIC before the authority, but they did not give the list of the super specialty hospital in which they have tie-up. They have simply stated that they have tie-up with super specialty hospital all over the country.
They have only mentioned about the details of the hospitals in Jamshedpur.
And they have only mentioned about the details of the hospital at Jamshedpur with which they have tie-up. The learned counsel submits that the tie-up with AIMS, Delhi, Vellore, Apollo Hospital, situated at metros, is of much superior level as compared to that of the hospitals at Jamshedpur. And he further submits that the finding of the authority that the tie-up arrangement of ESIC is superior to that of the petitioner is especially perverse inasmuch as they have not taken note of the fact stated in the exemption application. The learned counsel has then referred to annexure
24, 27
of the petition to submit that even the number of reference made to these hospitals have been mentioned along with the details of the expenses incurred for the same purpose. The learned counsel for the respondent ESIC would not point out any material from the records to show as to the names of the hospital with which they have tied up by way of super specialty arrangement. And apparently in their reply at page number 204, they have only referred to certain hospitals at Junction. That's all.
And it is not the case of the petitioner that we don't have tie-up with these hospitals. They have not a word in it.
Why will they say you have to tie up on you? It is for you to say that you have tie up with them.
We have made a statement that we have it.
The fact that they have tie up with AIMS you cannot deny that they have tied up with best of the hospital.
Definitely, my lords. And there's
And
no statement
if
that
you
we
have-
don't have tie-up with AIIMS. There's no such
You,
statement.
you don't, they will not have to make a negative statement. You have to make a
Okay.
positive statement that you have a tie-up with somebody, some hospital in New York,
May-
so that is better.
Well, may I put something forward? They are claiming that they are facility superior.
A second. In addition to aforesaid submission, the Learned Council has also submitted that for the period from 2000 to 2010 and 2014 to 7/8/2017, the petitioner was enjoying exemption, and so far as the period from 1/5/2010 to 7/8/2013 is concerned, the said stood rejected only on the ground that the application seeking exemption could not be granted retrospectively
In terms of section
And- in terms of section 95.
91A.
Sorry, 91A, he submits that the dispute with respect to this period is pending in division bench as the provision of section 91A is under challenge. The Learned Council has submitted that the petitioner has been giving the same benefit. There can be no reason, the petitioner having enjoyed the benefit throughout, there can be no reason to deny the benefit suddenly for the period involved in this case. That's all. Here was one count. Again.
Second is this sickness benefit.
Hmm.
बीमारी लाभ कर्मचारी राज्य बीमा निगम द्वारा इस लाभ के अंतर्गत कुल 91 दिनों के लिए उसके औसत दैनिक मजदूरी का 70% देय है। साथ ही कर्मचारी राज्य बीमा के अंतर्गत कर्मचारियों का निबंधन होने पर उनके किसी भी अवकाश पर भी प्रभाव नहीं पड़ता है, जबकि कंपनी द्वारा यह बताया गया है कि नियुक्ति की तिथि से ही उनके कर्मचारियों को 100% मजदूरी के साथ बीमारी लाभ दिया जाता है। साथ ही 180 दिन के लिए दैनिक मजदूर का 50% देय है, परंतु कंपनी के द्वारा यह स्पष्ट नहीं किया गया है कर्मियों को बीमारी लाभ उनके कुल जमा सिक लीव के विरुद्ध दिया जाता है या जिनके पास सिक लीव उपलब्ध नहीं है उन्हें भी 180 दिन का बीमारी लाभ देय होता है।
Each of the ground you must have assailed in the writ petition, no? It is difficult to translate. You must have assailed each of the grounds in the writ petition.
Has not been dealt with individually, we have mentioned in the comparative chart which we have filed along with the exemption application.
What do you want to say to this? They are not considered it in totality.
Can I make it simple? My only point is, it appears to me from the order that the comparative chart which the ESI had given, which is at page 204 onwards, was only considered. My reply to that comparative chart was not even looked into. Kindly come and I'll show it why I'm saying. One comparative chart is at page 204 by the ESI.
Yes, 204.
204.
Yes.
Medical benefit number 1. They say that the benefits in the first column under the ESI scheme. And so far as Tata Steel is concerned, they say details of benefits under the employer scheme. This much. Right, my lords? Similarly, for the next benefit. But this 206, 205 is double, has been just repeated 206. Sickness benefit, they have written one paragraph, only 2 lines. Enhanced sickness is not provided. This is what was filed by the ESI. They are entitled to file that. I have no difficulty. Now, in response to this, notes, this comparative chart at page 209, annexure 17, we filed a rejoinder. And along with it, notes, we are given for page 217 our reply. Go to page 217 is folded. Yes, this is my reply. And then exactly table wise, chart wise, the way ESI had given their comparative assessment, we had also provided our comparative. Now,
This has not been done.
now you actually come to page 217, last paragraph under my column.
Yes.
Tata Steel provides free treatment to its employee and their dependent relations in respect of the above disease by referring to RTIICS, Amrit, Medica Super Specialty Kolkata, AIMS, CMC, Bangalore, Apollo, and other
It is
hospitals.
this which has not been done.
Yes. This is just that they saw that comparative and they said this is not. So where is the consideration of this? All these factors have not been considered. And hence I feel aggrieved that had you considered this, you would have reached another conclusion.
Yes, what do you say? This, they filed a reply to your comparative chart. Has these been considered by the, yes, state, you tell us, it is your order.
Yes.
Have you considered this? They have given a detailed reply chart wise. Is it your case that this was not filed? That is not your case. And the fact remains कि आगे पीछे दिया हुआ. Yes?
We have filed our complaint reply.
Just tell us what is your reply to this. Has this been considered? This comparative chart at page number 217, which they gave by way of parawise reply.
I took place page 10 of my counter.
Page 10. There is no counter affidavit to this. This reputation doesn't have a counter.
We have counter
WPL 2
2536.
2536. Your counter filed when?
Probably
Yes.
both date is 14th February 2022 also.
14 February. Filed when?
Probably filed on 15th.
Saha. Somebody Saha.
Saj was my employee.
No, Indrajit Prakash.
Release the class.
This is filed on. Has to be filed on was 22, 14th of February 2022.
Yes.
It's cited as counter affidavit on behalf of the respondents.
Yes, yes. This is counter affidavit on behalf of the respondents. Which paragraph are you seeking? Yes,
Paragraph 11 also.
para 11.
Yes, sir. Roman 1. Next page.
Page number, please.
Page number 10.
10.
10.
Yes.
This specifically stated, Lordship, that the benefits provided by TSI are substantially better than the benefits provided by Tata Steel. Lordship. And a comparative statement of benefits provided by ESI Corporation and Company is enclosed here with the ESI Corporation is providing comprehensive and broad in nature of medical benefits to the insured persons and their family without any upper limit of the expenditure. It is crystal clear from the submission of the petitioner that the medical facilities provided by the company is neither at par nor superior to the medical facilities provided by the ESI Corporation, that is permanent disablement benefit.
Which comparative chart are you referring to? What is it? You are translating your input model. It is a consideration of the rejoinder which they filed. They filed, ESIC filed a comparative chart.
Both filed. Initially both filed.
Initially they filed, then ESIC filed, and then they filed a rejoinder to it. Where is the consideration of the rejoinder? You see, they file an application for exemption, right? Certain points ESIC raised objection. Then they answered it by way of point-wise reply. In the same manner in which ESIC has raised objection, Where is the consideration? This, I just do not know what is happening. That is not there, no. So I remind it. I'm not going to decide it here on merits. And you should be aware that their exemption has a direct bearing in all the cases. This time they do not commit this mistake. Please don't do it. I'm asking them to furnish their written submissions also. Whatever with the objection, they will file their written submissions. And ultimately, the next round of litigation, if any, will be confined to that written submission. That should be the act. After all, there has to be an end to it.
And in fact,
Now you don't have anybody paid less than 21. This case has become, this act has become
In fact,
Redundant.
redundant for all, because
basically
they have
it
to amend
is,
it.
it is basically not for the corporate giants basically, but it is for the mass scale laborers.
Minimum wages
I
in that.
tell you, 21,000. Even domestic help is paid more than that.
The minimum wages.
Minimum wages is more than that. Minimum wages is.
Minimum wages is more than that. Not there.
So we intend to revise it. There's a
Ah,
proposal which has been sent. Until the central government approves, we cannot revise it. So we are stagnant at 21,000 for a pretty long time. I think it was pre-COVID 21,000.
So that should be sufficient.
We want-
Why should I enter into anything item wise, point wise?
Not at all.
Not at all, not required.
I am showing non-consideration of relevant factors, that's the code not
That's
provided.
enough.
30 months.
Okay. फिर से
First look out consent नहीं होगा.
consent क्या? नहीं तो आप justify करिए order. What do you mean?
नहीं, ये तो adversary में just.
Adversary को भी तो impute और justify.
बिल्कुल. But when
You see, fair consent or
your ship may hold that.
I will hold it, but I will also say that you are not able to satisfy this code
Yes, but
unless because my order has to be a reasoned order.
definitely got you.
So I have to say that you are not able to satisfy this. Or the learned counsels appearing on behalf of the parties. Yes. These writ petitions have been filed for the following relief. WPL number 2536 of 21 is relating to the period
2017 to 2020.
you have given me that chart.
The list of dates.
This is 25636. Okay. लिखिए तो. This writ petition has been filed for the following relief. इनका written submission से ले. The learned counsel for the petition has submitted that the petitioner filed application seeking exemption within the prescribed time for these periods. The applications have been placed on record. The ESIC objected to the application by filing a comparative chart. And their contention was that the facilities being provided by the petitioner to its employees / retired employees are not matching with whatever is being provided by ESIC. And ESIC claimed that their facilities are much superior. The petitioner filed rejoinder to the objection and gave a detailed reply. The learned counsel submits that the impute order reveals that the points taken in the rejoinder, which was placed by way of comparative chart before the authority, has not been taken into consideration while passing the impute order. The learned counsel, by way of illustration has referred to the facilities which are available by way of super specialty treatment in specialized hospitals like AIMS, AMRI और जो भी नाम है उसका डिक्टेशन में दिए. The Learned Council submits that the impugned orders refusing to grant exemption are perverse on account of non-consideration of the materials placed on record. He has further submitted that the petitioner has enjoyed exemption for the period from 2000 to 2010, 2014 to 7/8/2017, and for the intervening period, that is from 1/5/2010 to 7/8/2013, the exemption has been rejected on technical ground by stating that retrospective exemption cannot be granted, and the said order is challenged before the Honorable Division Bench, along with challenge to the provision of section 91A. 91A you are challenging. The Learned Council for the state, though has opposed the prayer, but has not been able to point out any consideration of the rejoinder which was filed by the petitioner to the counter affidavit filed by the ESIC
To the
before.
comparative chart.
Sorry.
To the comparative chart.
Yes, through the comparative chart before the concerned authority who decided the claim for exemption. The Learned Council for the ESIC also could not point out the consideration of the rejoinder by the authority while passing the impugned order. In view of the aforesaid facts and circumstances, there is no doubt that the rejoinder filed by the petitioner by way of comparative chart to the comparative chart filed by ESIC has not been considered by the authority. And therefore, the impugned orders refusing to grant exemption for the period involved in the present case cannot be sustained in the eyes of law, being perverse, and is accordingly set aside. The matter is remitted back to respondent number. Respondent number 2. The petitioner and the authority and the authorized officer of ESIC is directed to appear before the respondent number 2 on dash along with a copy of the DIT records. उनको मिलेगा नहीं मिलेगा we do not know उनका record कहाँ पर. Along with a copy of the DIT records.
Along with the documents they intend to write, because
DIT records रहने. सारा चीज तो है ही. Along with a copy of the DIT records. And the authority shall pass fresh order after granting an opportunity of hearing to the parties, and each date of hearing be communicated to the concerned authority through email as may be provided by them by filing their representation. In order to ensure that there is no gap in the matter of consideration of the claim for exemption, the authority the authority may call for written submissions from both the sides. The needful be done by the authority by passing a reasoned order in accordance with law within a period of 3 months from the date of their appearance. The final order so passed be communicated to the parties through mail.
Only one thing, during the pendency of the writ petition, or should the additional demand notice under section 45A, for which we are trying by way of amendment, but that IE was allowed, so state to be part of this main writ petition. That demand or
This has been stated in other cases also till the exemption is decided.
At this, the Learned Counsel for the petitioner submits that during the pendency of the petition, the respondent ESIC has raised demand for the period involved in this case. He has submitted that the demand be kept in abeyance till the disposal of the matter by the authority. The learned counsel has also submitted that the fact that the exemption was in view of the aforesaid submission, the demand raised for the period involved in this case is directed to be kept in abeyance till the disposal of the matter by the authority. That's all. Parties to cooperate.
Lakshmi kindly grant us some more time after disposal of the lordship, so that we got to challenge that option.
I don't know. I really cannot say. We should have challenged it anyways. It has
It didn't have been challenged in the instant petition by way of amendment.
That's that is demand dated
Dated
August
16th August 2020
for both the periods.
for the entire
Demand but then
demand memo lordships. It has been mentioned in the order dated 18/3/2025.
18/3/20.
Disposing the paragraph number 4. The final.
Paragraph 5 lordships.
This was challenged in only that the demand raised under section 45A of ESI Act 1948 was challenged through IA number 5502 of 2021. Which was for payment of rupees 41 lakhs 07,825 as mentioned in order dated 18/3/2025. The petition seeking amendment was allowed and the challenge to the same remained pending before this court. In view of the aforesaid circumstances, the demand raised shall be kept in abeyance till the disposal of the matter by the concerned authority. What is the next?
As the rest matters, lordships, there are 2-3 companies more left in the matter. Tata Pigments.
Tata
Tata-
Pigments, we have already disposed of yesterday 2 matters. 2 matters or 1 matter?
Two matters.
Yesterday 2 matters, and earlier also
One
2 matters. 4 matters we have already disposed of. We are actually asking them for fresh adjudication, and we are also asking them if required, you may be also called upon to say. Because what would I must indicate that whether the referral facility and whether the facility to retired employees and their spouses is available for their employees also or not, and your agreement with them is required to be considered.
There are 3 matters also which of Tata Pigments will also be kindly posted tomorrow.
Okay.
Serial number
2,
let's see, number 6
6
and 7.
and 7. These 3 matters, right?
Yes, sir.
So 8th is gone. No, sorry, 8th is there. This is 9th is done.
9 and 11 is done.
9, 11
And serial number 5, 3 lots. 3.
and 3 is done. Correct? Then you have Indian Steel and Wire. I think it has merged. Is it existing?
But it has been merged
So
with Tata Steel in the year 2024.
your claim for exemption has been rejected.
Yes, madam. I was granted exemption for the period
The
2014
serial
to
number 4.
15.
Serial number 4. Tata Pigments you want it to be placed tomorrow. Who will act?
My senior will Because in those matters, the lordship has already ordered the other matters
Yes,
for different period lorships.
Hmm.
I believe same order will be.
we'll see that. I recall it, it is the case, serial number 6,
2, 6, and 7.
2, 6, and
2, 6 and 7. At the request of the counsel for the petitioner, these 3 matters are directed to be posted tomorrow.
Well, if it may be taken up yesterday or tomorrow also.
भाई आप अपना बहस करें
But it has to be.
अच्छा देखते तो है क्या
हाँ, yes,
पूरा बैच है नहीं
हाँ, yes, certainly.
देखिए just a moment. I just yeah Indian Steel and Wire.
Yes,
Yes, what is it? Is
No,
there
the
any improved
exemptions.
order?
yes, ma'am.
It
It
is
is
for
annexure
which
10
period?
and 11, madam.
Annexure
No.
10 and 11.
Yes, ma'am. Prior to starting my last, if I raise the case one. For the period of 1/4/2014 to 31/3/2015, I was granted exemption. Thereafter 1/4/2015 to 31/3/2016 and 1/4/2016 to 31/3/2017, I was granted exemption. For the rest of the period, my lord, for 2017-18, 18-19, and 19-20, they are the impugned order. So I placed my application well within the period time for the renewal matter, and it was not decided within the stipulated time. And in fact, my lord, the comparative chart,
Where is
there-
the improved order?
that is annexure 10, my lord, page 147.
कोई इतला बीमारी इतला
हाँ।
विस्तारित इतला अपंगता इतला
In fact, my lord, the other page, my lord, another annexure 11. So ditto copy of it. It's a replica of annexure 10.
where is your application seeking exemption?
My lord, it's starting from annexure 4, my lord, for the period 2017-18.
Annexure 4 page number?
Page number, my lord, is 82 onwards.
80. Why at page number 83 you are mentioning remuneration of 15,000? It was enhanced or what? It was enhanced to 21,000.
It was enhanced to
It was
21,000.
But during that relevant period, it was 15,000.
Yes,
Because that was one of our performer. How many employees may be covered or may be
That is
excluded?
why I wanted to see what is the stakes involved. So you will calculate only for the for 137
Only 130.
and nothing more at best. You are taking the benefit from Tata Steel.
yes,
There is one more judgment where with respect to Tata Steel where it has been held that they are entitled to exemption.
my lord, it was a.
Gemco.
It was a
Gemco.
Gemco.
They are also associated with TMH.
Yes, my lord, but this is the judgment, my lord.
यही है ना?
Gemco का एक batch cases हुआ था.
हाँ बैच केस हुआ था.
It was declared to be a sick company. Thereafter,
भाई सिक कंपनी आप रही है कंपनी बट बाकी लोगों को क्यों सिक बना रहे हैं? हाँ? Your sickness will not absolve you from your liabilities under ESI.
rather I am providing better service than what is, yes, ma'am.
So according to you, you are having tie-up with TMH
Yes, ma'am.
or Tata Steel. And where is your agreement?
Agreement नहीं है, इसलिए हम बोल रहे थे कि next day हम लोग करेंगे. Tomorrow मैं आपसे place it on IE.
आइए.
IE फाइल कर सकते हो, नहीं तो otherwise supplementary तो लेंगे नहीं.
आपका एप्लीकेशन भी टाटा स्टील ही बनाती है
Fleet application.
नहीं फिट एप्लीकेशन भी और एप्लीकेशन से भी एक्सेप्शन भी
Everything is on
style of writing I can make out
Format.
correct
The
they are
font,
the same thing
the font, everything.
But the original power and the force behind everything.
आपका सेम नहीं है just maybe
Comparative,
page
page
125
yes.
you see you are making different reference it is not reference to TMH
But the TMH we have stated itself now, that we are
page 3 and annexure 3 इसका क्या है
no,
annexure
page
हाँ,
84, page 84 is what we have stated.
I'm at your application only page 125
No, page annexure 4 is my application.
yes yes I'm reading your application
Yes, 84 my lord, free medical aid to all employees and their dependents, including hospitalization companies, own hospital and all in Tata Main Hospital, Tin Plate Hospital, Mercy Hospital, etc. Relevant agreements with these hospitals are included. Also, Peerless Hospital, Peerless Kolkata, CMC Vellore, RMTI Kolkata, and other impaneled hospitals as recommended by medical board or approved by the management. That is at the top of, but the left hand side it is 12 members, the other side members. Page 80.
so you have tie up with Tata Main Hospital
Yes,
and other hospitals where is
Yes.
the tie up agreement how do I examine it what kind of tie-ups you have and where is the enclosure to your application? You have just annexed the application. Where is the enclosure to your application? You're talking about certain tie-ups.
yes. Otherwise,
It is not a
then
case. It is not a case.
Yes.
Just a moment.
Yes.
It is not a case where you are tied up with TMH
Yes.
and your employees go exclusively to TMH. And then from TMH, whatever reference is made is done.
Yes.
That is not your case.
Well, annexure 10 months, it is the impune order. They also admit that TMH is there. It
Yes,
is a-
TMH is there, but
Yes.
your application is saying about other hospitals.
But it says about TMH also, it says about Tin Plate Hospital, which is my parent hospital member. My annexure 10, page 147. They themselves admit to that fact.
Also, as you said, the agreement would be necessary because in various cases we have seen that the agreement does not cover retired employees.
Agreement is required to be seen. That was required to be examined. Did you place the agreements
Yes,
before the
yes.
authorities?
It appears on us that we have given.
You have given.
Yes. I have not enclosed here, my lords. The
84.
relevant agreement, 84,
84.
relevant agreements with these hospitals are enclosed.
84. Where is it?
Well, 84 minutes, the first paragraph, the last line.
Free medical aid.
Free medical, last line. No. Relevant agreements with these all hospitals are in.
So there is no consideration of these agreements. What is the nature of tie-up? What all facilities they are being provided? That is not there.
It is not there.
Now, do you exist as a separate company or
No, no.
who is the company?
My
Which
Tata
company?
statement. That's
So
it.
you have amended your cost rate?
No, no.
Then who will go?
But therefore, one end doesn't have.
Therefore, what?
one eight.
Just. That amendment is required, no?
Yes, ma'am, it is certainly.
When did it merge?
2020.
2024.
Yes.
This is all prior to that.
Yes,
This
all
is
prior,
period is
yes,
all
all
prior.
prior to that. All prior.
But at least the liability, if any, has to be borne by
Ma'am,
that.
certainly, ma'am. No,
So you have to file your affidavit,
Yes.
IA to that.
yes, ma'am. Confinement tomorrow. If it will keep on us tomorrow.
हो जाएगा कल
हाँ कल हो जाए, कल करा दें।
इतना आसान मत समझिए टाटा स्टील आपका एफिडेविट कर देगा बहुत मुश्किल है
Then ma'am, अभी let it be not simply not.
कल Mr. Indrajit Sinha will be there. Where is he? Yes,
He's asking
this
about
is, I know, but you are there. So what will happen to this company? It is your company now. You have to take your responsibilities and liabilities and everything. You have taken the asset, you take the liability as well. So this matter has to be taken care of by Tata.
In fact, I had gone through the promotership agreement with the at 5. So it talks about that only those liabilities which were declared before at the time of insolvency, or only those were taken
This has
over.
not been. This has not gone into
No,
insolvency.
this is not going.
This has not gone into insolvency. It merged with
It
Tata.
was. So only those liabilities which were disclosed at the time of merger stood with Tata Steel. Otherwise, all liabilities were with the existing promoters.
Otherwise,
This
ma'am,
is one
So
such
the
clause.
terms
but there
and
was
conditions.
there was
This
the
is there,
insolvency
page
proceedings,
72.
ma'am.
Page
Insolvency
72.
proceedings.
Page 72. This is the clause. Page 72.
Who will bear? Then ultimately, what will happen to this?
Well,
Who will
otherwise,
bear
we
this
have to
liability?
bear. ma'am.
Who has to bear?
We have.
We means
Ma'am,
I
the Tata.
it is not.
नहीं, Tata.
They say that Tata Steel is not ready to accept the liabilities as per the scheme of merger. Yes, just a moment. Did you raise your claim
But it appears that
in NCLT?
it appears we were not noticed.
What do you mean you were not
We were not
noticed?
informed that.
There is a paper
But
publication
it
to
appears
this.
so. It is not
The
there.
Labour Department is fully
Definitely,
represented.
Mother. It appears what departments were represented at page number 68, which is the Government of Jharkhand, Electricity Duty, and the Commercial Taxes Department.
There is a full-fledged
I agree, Manoj,
proceeding.
I agree.
There is a full-fledged paper publication.
I agree, Manoj.
If you do not stake your claim goes.
But though,
You have raised any demand for this period?
yes, there was a demand.
Where is that demand?
Ma'am, this is the proceedings of amalgamation.
Where is the demand?
Right of course, they said that yes, they have raised a demand with regard to this.
You see whether you will be able to realize or not able to realize
Manoj,
is something.
because in the
That situation will come
in
later.
the scheme of settlement, the existing liabilities were kept intact without its disclosure.
No, you have to stake your claim over there. It is not like that.
Manoj, I agree.
Existing
But
liabilities.
if there's an existing the scheme which was formulated by them, they specifically mentioned that all the liabilities not disclosed in the audited balance sheet in note to accounts would be of the personal responsibility of the existing promoters to discharge.
You see, we are not here to decide your
Definitely,
liabilities.
Manoj.
We are not concerned, but at least the company is not existing as of now.
Manoj.
So that amendment is required.
That amendment is required. Also.
In the scheme of amalgamation, ma'am, what has been stated.
No, we are not bothered
Ma'am,
about
yes,
it.
ma'am, certainly, ma'am, I would.
Tata Steel will have to file an affidavit
Yes, ma'am, we have.
on IA
Yes,
for substitution
Yes.
of the name.
Yes.
And their liability will be as per the
yes,
Definitely, Manoj.
agreement. only.
certainly.
Do you exist for any other purpose?
No.
No. हो जाएगा कल तक बोले WPL number
Let it be next. The instruction.
WPL number then I'll post it tomorrow only. These matters will be there. I will segregate it for these Tata pigments. I will dispose of tomorrow and your matter will remain, but I'm just capturing whatever has gone in the court proceedings as that I remember. WPL number 3314 of 2021. The learned counsel for the petitioner has stated that the application seeking exemption was filed along with the agreements of tie-up with different hospitals. But terms and conditions of the agreements has not been considered by the authority while passing the interim order, rejecting the claim for exemption. We asserted that the period involved in this writ petition is from
It is from 2017, 18 months, 18, 19, and 19,
2017,
17, 18,
18,
18, 19,
18, 19,
19.
19, 20. इसका जो WPC number 1173 of 22 का valid 1173 of 22. In the midst of the argument, the learned counsel for the petition has submitted that the petitioner company has now merged with Tata Steel Limited,
Yes.
and therefore an appropriate petition is required. Yeah, 1173. आपका DFD हो गया 1173 of 22.
We have filed a CNP.
And I think this period from 1/4/2018 to 31/3/2020 is covered in WPL 1173 of 22.
We have filed CNP 653 of 2022.
You should have known about it. A number of repetitions. Your 2 cases, Denko's 2 cases. 4 repetitions. दिखाइए भाई उन लोगों को दे दीजिए. और ये वाला जो है ना, your file CNP
Yes,
pending.
pending 653 of 2022. 1173.
1173 का कौन सा पीरियड है बताइएगा, because overlapping तो नहीं हो सकता.
Like 1/4/2021 to 31/3/2022.
I don't know, there is a, it has been struck off over here, that is behind. Struck off in pencil. So I do not.
The instruction which I have.
Overlapping order नहीं हो सकता.
Overlap.
The learned counsel for the petitioner is also submits that other repetitions were filed by the petitioner company being WPL number
1173 of 2022.
1173 of 22 and there are 2 cases.
Well, the present case is this one.
अच्छा, ये restore हो गया.
High store.
And he will inform this court the period which was involved in that case.
Well, it's 1/4/2021.
He submits that as per his knowledge as of now,
Yes.
the period involved in the said case is from 1/4/2021
2021
to
31/3/2022.
31/3/2020. तो इंडियन आयरन एंड स्टील का एक ही मैटर है आज के बोर्ड में.
Yes. एक ही.
When do I post it? I post it tomorrow.
Tomorrow, but then after a week.
Okay. Let this case. I'll post it tomorrow. कल नहीं सुने.
ठीक, ठीक.
This case is also being posted tomorrow. However, the same will be. That should be enough.
That is enough.
और बताइए कौन सा है? Which other case?
The other matters, before that, if I may submit one thing. So as this, when the three lordship has remanded the matter to the respondent state to decide the application of fresh. But if you kindly observe that they will not dismiss it on technical ground of section 91A that they will not come to this.
No, वो तो हो नहीं, सवाल ही नहीं, remand होगा तो 226 में they have to decide. They will not be able to.
But
If
you
you
have
have
observed,
you have stated that the application was filed on time.
madam,
बस हो गया बात खत्म.
you kindly observe that
I
they
don't
decide
need
on
to
merit,
observe
on merit lordship they decide.
I will not say anything. It will be decided on Monday.
The other lordship matter pertains to the Tata Steel Utilities and Infrastructure Services
Hmm.
and TRF Limited lordship.
Tata Utilities, Tata Utilities, Tata Utilities,
And TRF
and
lordship
TRF.
asked for.
Who is for TRF
We are appearing in all these matters.
in all these matters? So which matter should we take up?
Lordship may kindly post this matter lordship next Monday.
For Tata Pigments, we will argue tomorrow.
Tomorrow.
So we'll decide Tata Pigments tomorrow. 3 matters, right?
Lordships.
Then what about Tata Utilities?
Tata Steel Utilities lordship may kindly post it on Monday lordship. So
No, we are posting it. We are not segregating it,
lordship.
but with a clear understanding that tomorrow you will do Tata
Tata
Pigments.
Pigment. And Monday lordship.
Post these cases, remaining cases tomorrow. The council for the petition has submitted that tomorrow they will advance their arguments with respect to
Serial number
the serial number.
2.
With respect to WPC number 6961 of 2016, WPL number 3900 of 2021,
and 4287.
and WPL number 4287 of 2021, all relating to Messrs. Tata Pigments Limited. That's it.
Okay.
ये कोई एक साथ बैच तो बन गया लेकिन it is every case is a different case. Every year is a different year. I tried कि एक साथ नहीं हो सकता है. एक साथ करने से फिर वही खिचड़ी बन जाएगा.
Okay.
ये ना जजमेंट यही रखिएगा जब तक ये मैटर्स चल रहा है. इस जजमेंट की जरूरत.
From the supplementary list under heading for orders, item 17, first appeal 239 of 2026.
This has been listed for what purpose?
In compliance of order dated 29/6, we are ready with the count and we're not fine.
The learned counsel for the respondents files reply counter affidavit during court proceedings which is taken on record. Do you want to say anything to that?
No.
No response?
This is to the reply of the IA that he has filed.
Okay. They have agreed that you,
Yes, Your Lordship.
Their interest has been substantially represented in the.
do you say so?
Lordship,
Your interest,
yes, we are.
interest of the deceased is
Your
substantially represented.
Yes, Your Lordship.
Where is that value?
IA number 8638 of 2026.
I think we had drawn some order on the last day.
Yes, Lordship. Wait.
IA number 8638 of 2026. The learned counsel for the appellant has submitted that the implicatory application has been filed seeking to amend the cost title of the first appeal. For the reason that respond number 1, namely Rukmi Devi, comma respond number 7, namely Jetni Devi, and respond number 10, namely Ramesh Arabia. All 3 respondents had died prior to filing of the instant first appeal. And they have prayed that their names may be permitted to be deleted from the cost title. And they are seeking
Substitution of the respondent 10.
substitution of respondent number 10. So his interest is not substantially represented. Respondent number 10. The legal years of respondent number 10 are on record.
Even his lordship, his brothers are already on record. Lordship. Lordship may see page number 29, genealogical table.
This respondent number 10 has expired on 2/12/21.
And
His estate is not represented. But notice has to go to the legal years also. It will not go to the legal years. Has it gone to the legal years?
Lordship, we undertake to file wakalatnama.
On behalf of the legal years of respondent number 10,
Yes, Lordship.
you file your wakalatnama, then I will pass on.
We have the wakalatnama with us, Lordship, right now.
You file it. I'll pass it on tomorrow. अभी तो 4 बज गए परसों फिर से Mr. नाम भूल गए I forgot your name.
Akari Prakhar Sinha.
Mr. Akari Prakhar Sinha, advocate, undertakes to file wakalatnama on behalf of the legal heirs and successors of respondent number 10, whose details have been mentioned in paragraph 11 of IR number 8638 of 2026. Yeah, let it be done by tomorrow. Post the application. The reply filed to the interlocutory application by the other respondent is taken on record.
Look, I am getting the respondent number 40.
From the daily call list, I'm ready for final disposal. Item 1, WPL 2430/2030.
ऐसे भी आज फिनिश नहीं होगा हम स्टार्ट कर देते हैं
टुमारो करने के लिए कॉस्ट लगा दो, इसलिए आप आराम से बैठिए और कहानी सुनिए। कोई बात नहीं।
सुन लीजिए नोट कर लीजिएगा
सुनिए, नोट कर लीजिए। फाइल भी चला गया क्या? घर ये जो पेज पढ़ रहे हैं आप बताइए।
बस केस बस अवार्ड के लिए वी आर अगेंस्ट द अवार्ड the departmental inquiry was held to be not fair and proper and after that order passed the award has been rendered after hearing
no further evidence.
no further evidence was there but fact remains because we have we are arguing on other points. What had happened to just give a brief overview, this employee was working in a bank. He received ₹5,000 from a customer. Instead of crediting in the respective bank account of the customer, he took the amount home. When this aspect came to light, he admitted it. Initially a so-cause was given. So-cause के बाद he admit कर लिया अपना guilt. हम लोग चार्ज दिए चार्ज पे इंक्वायरी हुई और इंक्वायरी के दौरान भी इन्होंने एडमिट किया अपना गिल्ट. सो एडमिशन है एक पहला एस्पेक्ट तो ये प्लस अवार्ड में बेसिकली प्रोसीड किया ये बोल करके कि देयर वाज नो इंक्वायरी रिपोर्ट सर्व्ड अपॉन हिम. प्लस वी कैन शो डॉक्यूमेंट्स व्हिच वर एग्जीक्यूटेड आल्सो कि इंक्वायरी रिपोर्ट वाज ड्यूली सर्व्ड अपॉन हिम. And it further says that there was no second so-cause given.
The impugned order is dated 25/5/2012.
Yes. Yes.
Just tell us which is the order which is under challenge.
मतलब the award.
There are two orders.
Yes, punishment order is below page number 51. This is the order against which the below employee moved.
No, I'm not that. Which is the order under challenge in this?
100, yes. 110. 110 is the below award starting. अगर मतलब this 116 से relevant होगा अगर बोलेंगे पढ़ेंगे.
आप दो ऑर्डर चैलेंज.
हाँ.
कौन
ये-
कौन सा?
यस एक तो है जो होल्ड किया था नॉट फेयर एंड प्रॉपर वाला है नेक्स्ट 18
That is 25/5/2012.
करेक्ट
And the second is the final order,
राइट फाइनल अवार्ड
right? Both orders. I have a query here.
Right.
After the inquiry was held to be unfair, was any evidence led or not?
नो
No evidence was led.
No.
So if the inquiry is ultimately held to be fair and proper, then the matter has to be remanded for
करेक्ट
consideration in terms of 11A.
राइट
And if the inquiry is held to be improper and that order is sustained, then in absence of any evidence, the impugned order has to be sustained.
well there is no evidence after that therefore yes true so if inquiry is held to be fair and proper then certainly there is no evidence on that basis
That's
not simple. But only one aspect I would say that if there had been the evidences already on the records and it was not looked into, then what's it? Another aspect will come.
But once the inquiry is held to be improper, no material collected during inquiry can be considered by the labor.
Additional evidence was not. Yes.
No material can be considered,
Correct.
whatever be it.
Correct. Whatever was the
Whatever it
evidence.
is as good as no inquiry done.
but therefore we have challenged
That is why I asked you whether both the orders are
Both
under
the
challenge.
orders.
Just one of them.
Correct. Yes. So that is why probably this order was also on the challenge because there had been evidences already there and those evidences were not. But may I read the first order first?
Yes, first order. That is the core.
Correct. Page 19, Section 16. Heard both the parties on preliminary point. Management produced MW1 Suresh Prasad Sharma who proved document as exhibit M1 series, M2 series, M3 series and W1. Main argument advanced on behalf of the concerned workman is that the inquiry मतलब एक चीज खाली हम पॉज करके बोलते हैं लास्ट टाइम हम बोले थे कि लोअर कोर्ट रिकॉर्ड मंगा लिया जाए आई होप आ गया Right. Main argument advanced on behalf of the concerned workman is that the inquiry conducted by the management was not fair and proper. In this respect, evidence of Suresh Prasad Sharma is very much material. He stated in the cross-examination that I am not remembering the name of the inquiry. I do not remember the name of the presenting officer of the manager. I cannot say if inquiry notice was given to the concerned workman. I cannot say whether second so-called notice was given to the concerned workman before passing final order of dismissal. The concerned workman had not confessed his guilt before me. I was not present in the inquiry. I have not gone through the inquiry report. I cannot say about inquiry report. It shows that he has got no knowledge about the inquiry. I cannot say about inquiry report. He could not say whether any notice was given to the concerned workman. On behalf of the concerned workman, 1991 BLJR 567 has been referred. Also, 2007 FLR in which Honorable Supreme Court laid down disciplinary proceeding misconduct inquiry against chief cashier for disobeying order of superior, found guilty and show-cause notice issued. In view of evidence, the respondent could not be held responsible for any misconduct. A single act of omission or error of judgment would ordinarily not constitute misconduct. but an error of judgment, learned single judge has rightly held that piecemeal consideration of first charge by inquiry officer and disciplinary authority led to wrong conclusion which is not permissible in law. Learned single judge came to the conclusion that no misconduct has been committed by the petitioner. The learned single judge, by exercising his power of judicial review, has rightly held that piecemeal consideration of first charge by the inquiry officer and the disciplinary authority led to the wrong conclusion which is not permissible in law. Considering the facts mentioned above, that without proving inquiry report, without giving notice to the concerned workman, and without presenting the inquiry officer before this court, the management produced the person who does not know about the inquiry. It shows that no notice was sent to the concerned workman and inquiry was conducted by the management without following the principles of natural justice. So it is held that inquiry conducted by management is not valid.
Did the workman file a separate petition for the decision on this point?
No. They did.
There must have been a separate petition on the point.
And there should have been, but because it merged in the above. They both because, things happen. Many a times, because if the this is 5, 6,
Where is the written statement of the workman?
right,
Where is the statement that the inquiry was not fair?
right. Kindly plus page number 72.
You have annexed it.
Page annexure 12. ये मैनेजमेंट का
Annexure
ये है मतलब वर्कमैन का annexure 13 page 70
72.
70
Yes, it is there.
बोला para 6 page 72
आप इसको
para
ऐसे
6
देखिए. Para number 4.
course yes by the order dated so and so the workman had been placed under suspension for his measurement of ₹5,000 in its SBI account number so and so. Thereafter a charge sheet had been served upon him from so and so and following charges been framed against him, accepting the cash and paying slip from Ramlakhan Singh for ₹5,000 on 30th April 96 for credit to SB account number so and so of Sri Vijay Kumar without ascertaining that the receipt was not recorded in the manager's scroll, not directed the consumer to get the receipt scrolled as per procedure, which is a minor misconduct under clause 19.7 of bipartite settlement. Handing over of the receipted counterfoil of pay-in slip to the customer without scrolling the receipt in the cashier's receipt scroll and not releasing the voucher or posting to the respective account thus violated bank's procedure, which is a minor misconduct under clause so and so settlement. Carried this cash
See, he
or
has spoken volumes about violation of natural justice. And what your witness has done.
kindly have a look. क्या time है? वो ठीक है डिले के पॉइंट पे बाद में बोलूंगा कोर्ट की क्वेरी कुछ और है because he is asking me to argue on delay also because there was a delay in the reference and final award. So I'll come to that later. Let us see the management witnesses.
There is only one witness who was produced by the management.
MW1,
That is it.
page 88.
Yes. He has not stated
He
anything.
did not.
He did not say anything about the inquiry. He has no knowledge about the inquiry. And this workman is speaking volumes. Then the inquiry was unfair. That order is correct.
एक बार खाली MW1 देखिए page 88
Not page 18.
देख I am working as manager of the bank of Maharashtra at Ramnagar. In the year 1996, I was working as a special assistant in Patna branch. Concerned workman was retired compulsory. In 1996, inquiry was conducted against concerned workmen for not depositing rupees 5,000 on the same day while working as cashier. Departmental inquiry was conducted against the workman. Workmen concerned participated in the inquiry. Inquiry was conducted fairly and properly. Concerned workman confessed the guilt and charge was proved against him and he was compulsorily retired from the service of the bank. Annexure A to E are photocopies of the inquiry report marked Exhibit MC. Photocopy of check of rupees 5,000 and bank statement of account and other documents photocopies are marked Exhibit M2 series. On this basis, he compulsorily retired from service. Then, Malas, his cross examination upon which reliance has been placed. Let us see, Malas, these exhibits for a moment. Inquiry report is below.
He only considers the cross examination.
He only considers.
And these exhibits, what all exhibits were filed.
Yes,
Have
he
not
does
been
not
considered.
look. He simply says, you know, he in cross examination he has said that it appears he knows.
All these documents which were exhibited before the authority
Right.
have not been considered.
Not considered. And 1996 he was retired compulsorily. Sometime in 2012, 2003 he approaches for reference after much delay and award comes up to he has attained natural age of retirement. We have already paid him 17.
The reference was made in 2003.
3.
He was
96 he was punished.
96 after 7 years. The limitation is finished.
नहीं लगता है but delay and latches to lordship have considered.
Delay and latches we are considering.
And 2012 में WS दिया रेफरेंस हो गया 2012 में ही फाइल से रिटर्न अपना जो रिकॉर्ड यही नटसेल में केस है इस पे जो भी जजमेंट वगैरह है इतना ही केस और एक डॉक्यूमेंट बोलेंगे
इसमें तो वो कंसीडर ही नहीं किया है कोई भी आपका डॉक्यूमेंट्री एविडेंस कंसीडर ही नहीं किया
नहीं
किसी का नाम नहीं पता है उससे he has come to depose and place the entire inquiry proceedings.
He has placed the inquiry. That is on the record. Annexure 6 से लेके 8 देखिए कि एडमिशन है उनका इंक्वायरी के समय Inquiry report was frequently said, in the inquiry, Sri so admitted all the charges. And in his statement, Sri so told that incidents happened is not due to his bad intention, but it has happened due to genuine mistake. अब genuine mistake है, क्योंकि deliberate act है उनका जब वो एडमिट कर रहे हैं what's an admission? Annexure 6 is inquiry. दूसरा है मतलब इनका सिग्नेचर एनेक्चर 8 पे देखिए पेज 50 proposed punishment inquiry everything is before the court receives it and says, I will prepare a P. इनका पनिशमेंट ऑर्डर चैलेंज किया उसमें भी लिखना है कि प्रपोज पनिशमेंट ऑन विच हियरिंग वाज ग्रांटेड ऑन 14th March 97 पेज 51 पेज 46 से अगर 51 देखेंगे थिंग्स आर एविडेंटली क्लियर सब एग्जिबिट है
If the consideration in the matter of disciplinary proceeding being fair and proper, if that order goes, and again it is held that it was not fair, then you will have the right to give your evidence. Otherwise, you will not have.
Yes, yes. That is the law. तो इंडस्ट्रियल लॉ में थोड़ा सा तो ज्यादा मेटिकुलसली हम लोग को देखना ही होगा तो वही बट अगर मतलब मेरा
सुने आप रिस्पोंडेंट कौन है आपके सीनियर?
एक मतलब मेरा प्रपोजल था अब जो आजकल
आप आउट ऑफ कोर्ट क्यों नहीं सेटल कर?
वही हम बोल रहे हैं कि अगर मतलब अगर ये लोग कुछ ले कंपनसेशन तो हम लोग वी कैन एग्री बट मतलब
देखिए आई टेल यू आई एम प्राइम फेसी ऑफ द व्यू आई डू नॉट ये जो आपका इंक्वायरी रिपोर्ट फेयर एंड प्रॉपर वाला जो ऑर्डर है ना ये तो थोड़ा सा क्रिटिक है. None of the documents which have been filed has been considered. None of the documents. He has exhibited certain documents. Merely उसको नाम नहीं याद है. आके वो exhibit कर दिया पूरा का पूरा record आपके पास exhibit कर. उसके बाद you have to see.
प्रभास कुमार का
बता दीजिए हमको. आपका आपने इंगेज किया हमको कि उन्होंने आपको इंगेज किया? आज एडजमेंट करने के लिए इंगेज किया क्या आप एडवोकेट ऑन रिकॉर्ड? Find it out if the parties want to settle the dispute on such.
प्रपोजल कुछ आता है
आपका प्रपोजल क्या बताइए? As per the impugned order कितना पेमेंट करना?
हम तो यही बोले थे मतलब बाहर
As per the impugned order कितना?
impugned order मतलब तो ये जो है वो इनको 17 भी तो हम लोग दे दिए जोड़ जाड़ करके अब
फुल बैक पेजेस है?
फुल बैक पेजेस है तो हम लोग वो दिए हैं
फुल बैक पेजेस है?
50% हाँ 50% बैक पेजेस है 17 भी दे दिए तो थोड़ा बड़ा होगा डीए हुए सब जोड़ा आता है उस पे इनका आपत्ति भी नहीं था दे तो कुछ लमसम अमाउंट दिया जा सकता है
17B में कितना अमाउंट? How much?
61 क्योंकि 96 है उस समय का बेसिक कम था उस पे आपत्ति नहीं है फिर भी हम कोई लमसम अमाउंट दे सकते
Subject to what your counsel has to argue.
यस
थोड़ा देख लीजिए. ऐसा कुछ माइंड डिस्क्लोज नहीं कर रहे फिर ऐसे प्लान पीसी ऑब्जर्व कर. क्योंकि इनके लिए भी बहुत आसान नहीं. अगर ये ऑर्डर सस्टेन कर गया तो अवार्ड सस्टेन कर जाएगा.
फिर
इम्प्यू वो वाला फेयर एंड प्रॉपर वाला अगर ऑर्डर सस्टेन कर ले
तब तो
तब तो खत्म है फिर कहानी. फिर तो कुछ बचा ही नहीं बिकॉज यू डिड नॉट लीड एनी एविडेंस.
करेक्ट एक ही एविडेंस है मतलब अंडरस्टैंडिंग माय प्रेडिक्ट बट मतलब ओनली थिंग इज कि मतलब अगर वो भी होगा तो हमारा डिमांड होगा.
इनको तो
तो
कंपल्सरी रिटायरमेंट किया था ना
कंपल्सरी
तो पेंशन तो इनको मिल ही रहा होगा.
आज जो बाकी सब
बाकी तो सब मिल ही रहा होगा.
हाँ उसमें
पेंशन वेंशन मिल रहा होगा.
मिल रहा होगा तो कंपल्सरी टैक्स इसीलिए डिले भी किया बट हम
आगे मिस्टर प्रभाष कुमार. यस मिस्टर प्रभाष कुमार टेल्स क्या बोलना है? अभी डिस्पोजल करते हैं.
इसमें बोलना है लॉर्डशिप
आप बाहर से सुन रहे हो ना?
जी हाँ
आप बता दीजिए क्या बोलना है.
नहीं इसमें बता देते हैं ये जो पेज देखा जाए लॉर्डशिप में से द
First order dated 25/5/12. Mr. Mr. Prabhash Kumar, आपको बता देते हैं अभी तक का कहानी. There are 2 orders under challenge,
Yes,
right?
yes,
Domestic inquiry was held to be unfair,
unfair lordship.
and then the management did not lead any evidence,
Yes, lordship.
and the award has been passed, right?
Yes.
If the domestic inquiry is unfair, then no evidence from the domestic inquiry can be looked into.
Yes.
This is at best you can say.
Yes, lordship.
But the order which has been passed, holding that the domestic inquiry is unfair, is itself cryptic. कोई भी documentary evidence consider नहीं है. खाली क्रॉस एग्जामिनेशन को देख के ऑर्डर कर दिया.
I'm sorry, एक और witness examine हुआ है, sorry,
किसकी तरफ से?
हमारे MW,
एमडब्ल्यू की तरफ से कौन एग्जामिन?
Regeneration 17, sorry, हम भूल गए थे. Page number 93, on merit करके लिखा. So after that,
अच्छा, this is on merit.
हाँ, on merit. MW1 पढ़ के
तो अभी तो हम लोग डोमेस्टिक इंक्वायरी कर रहे हैं.
हाँ अभी तो
बताइए, ऑर्डर ऑफ डोमेस्टिक इंक्वायरी क्या सही है?
Domestic inquiry was not fair lordship.
Then I know there is a finding that it was not fair,
Inquiry
but
of,
that finding itself is perverse because it does not consider the chief at all.
nothing has been considered. Inquiry officer simply reproduced the charge
We
sheet.
do not know because that is not reflecting from the impugned order.
Yes, lordship.
Impugned order is not considering any of the exhibits. Please have a look at this.
हाँ, lordship में Annexure 17 देख लिया है. Annexure 17.
उसी में
Annexure 17 में जो है page 93. हाँ, ये
Page 93.
सुरेश प्रसाद शर्मा. I am working as branch manager at Ranchi. I was special assistant Patna. The concerned work conducted against him which rupees for 5,000.
नहीं आप impugned order पढ़िए. आप
नहीं,
impugned
इसको
order.
इसको इसको इसमें थोड़ा सा vital point है. This is the charge sheet issued by the management. Exhibit MW2. In the charge it is not mentioned as fraud and क्या लिखते हैं enable embellishment. Date of receiving of rupees 5,000 of the concern from it, I do not remember. Date of deposit is not known to me. It is not fact. I am not acquitted with the facts of the case. ये लिखते हैं कि date of deposit is not known to me. I do not know, do not remember. Lordship
कौन
may
सा
see
पेज पढ़ रहे हैं? Which page are you reading?
Yes.
Which
page
page?
93. Page 93.
93 is
हाँ,
the evidence of
MW2.
सुरेश प्रसाद
सुरेश
शर्मा और
प्रसाद
मेरी-
शर्मा।
Suresh Prasad Sharma.
हाँ.
No, we are on a different platform altogether. The impugned order holding that the inquiry was unfair
Yes,
is
Lord.
dated 25/5/2012.
Yes.
He is challenging that order. He is challenging that order by saying that inquiry was fair and proper. And this order does not take care of the materials placed on it.
In fact, Lordship, the inquiry was not fair, and that is the main point, crux of the point, Lordship. The learned tribunal has taken all the point into consideration.
You just see,
And
you
Lordship,
just see page number order dated 25/5/2012.
page 90 may be seen. And that is Annexure 16.
Yes, I'm there only.
Yes, I am reading, Lordship.
Yes, we have read it.
Management produced MW1 Suresh Prasad Sharma approved document as exhibit M1 series, M2 series, M3 and WN. Main argument advanced on behalf of the concerned workman is that the inquiry conducted by the management was not fair and proper. In this respect, evidence of one MW1 Suresh Prasad Sharma is very much material. He stated in his cross-examination that I am not remembering the name of the inquiry officer, which I have read, Lordship. I do not remember the name of the presenting officer of the management. I cannot say if inquiry notice was given to the concerned workman. I cannot say whether second so-called notice was given to the concerned workman before passing final order dismissal. The concerned workman had not confessed his guilt before me. I was not present in the inquiry. I have not gone through the inquiry report. I cannot say about the inquiry report. It shows that he has got no knowledge about the thing. I cannot say the inquiry report. He could not say whether a notice was given to the concerned workman. And thereafter, Lordship, on behalf of the concerned workman, decision has been cited then Lordship, the learned single judge came to the no misconduct having committed by the repetition. The learned single judge, while exercising a power has already held that piecemeal consideration, the first charge by the inquiry officer, the discipline of the led to the wrong conclusion.
These documents
Ah.
which were
And-
exhibited,
Yes, Lordship.
were required to be considered or not considered.
By virtue of the order dated 25/5/2012, he has considered all these
No,
points.
he has not considered any of the documents.
Page 92 may be seen. Page
Any-
90, page 92.
He has not considered the documents which have been furnished.
Page 92, considering the facts mentioned above, that without probing inquiry report, without giving notice to the concerned workman, without presenting.
Without proving inquiry report, those documents have been presented before the court. What do you mean
The
proving
inquiry
inquiry
officer,
report?
the management produced the person who does not know about the inquiry, so that no notice was sent.
You
to
see
the
that the copies of the inquiry report have been
inquiry was
exhibited.
conducted by the management without following the principle of natural justice. Inquiry conduct is not fair and proper. Lordship may see, just I am putting my defense, Lordship may see. Annexure 1 may be seen, Lordship, page 34. Page 29. Page 29, Annexure 1. Page 29, Lordship. Just at the top, the voucher, Lordship, rupees 2,500.
This is account number.
No, just above that, Dinant rupees 2 के पास में 2,500. Main crux of the point, Lordship, is on 34 to 96. Ram Lakhan Singh, he made a submitted. He has asserted that I made a deposited rupees 5,000, and in fact he had deposited only 2,500, and he went to bring back the next of the money, and he did not return back.
Let him complete his argument tomorrow. Who has given the written notes of argument? You have given written notes of argument.
Yeah.
This is it.
मैंने थोड़ा improve करना हो कर दो कहते हैं आप not similar I'll personally also
As the court time is over, court is case for further hearing. कल में कुछ रखते हैं ये एक बैच है बिग टाटा पिगमेंट्स कल ये टाटा पिगमेंट्स का एक बैच है वो ज्यादा टाइम नहीं लगेगा उसके बाद क्या हुआ आप तो मेंशन भी नहीं करते हैं क्या करेंगे सप्लीमेंट्री में इतने मैटर्स आप हर बार ऐसे ही एक ही कहानी बोलते हैं सप्लीमेंट्री में इतना केस नहीं दिख रहा आपको सप्लीमेंट्री में 18 केसेस क्या है सीरीज आप 2:15 से क्या करते हैं अब आप उठते समय 4:30 बजे विजिटेशन राइट का कहानी सुना हम क्या करें बताइए हम आपको मेंशन कभी डिसअलाउ किए आप समय जिस समय हम बैठते हैं उस समय आप आते नहीं है उसके बाद राइजिंग में आप बोलते हैं तो इस वक्त तो हम कैसे कौन सा प्रोसीडिंग इस वक्त नहीं कल तो नहीं हो सकता अब आपका आएगा नेक्स्ट आप
So serial number 22, a similar matter has been decided by your lordship. इसको disposal कर सकते
कौन सा सिंगल मैटर
हैं। ये ex gratia के लिए था, similar अपील से decide हो चुका है। Serial number 22 पे WPL 60/60/2025।
आप कुछ ही बहस करेंगे
Possible मसला है।
कौन सा ऑर्डर इसी ऑर्डर से डिसाइड किए हैं
Lordship similar है। दो cases में वीडियो रेटिंग है।
ये तो कोऑर्डिनेट बेंच ने डिसाइड किया है इसी से कवर्ड है
Lordship
कल तो नहीं हो पाएगा नेक्स्ट वीक सीरियल नंबर 29 अदर साइड कौन
22 Lord
22 अदर साइड कौन
अशोक यादव सर, अमित दास सर, सीनियर दास।
अगला डेट में आप मेंशन करेंगे 2:15 बजे, तब उनको मिला, उनको एडवांस नोटिस देंगे, ठीक है, इसको सीरियल नंबर 22 में डाल दीजिए, ठीक। अब आपका आगे नेक्स्ट गाइडेंस फाइंड
सीरियल नंबर 3000
नहीं कर सकते, सप्लीमेंट्री में इतना केसेस रहता है, वैसे कंटेस्टेड केसेस रहता है। 3 में क्या था, बोलते से
फ्री में था, चूंकि एक्सपर्टी अवार्ड है और वो प्रोसीड कर रहे हैं, एक्सक्यूशन प्रोसीड उसके अगेंस्ट में हम आए हैं, और जिस पर वो जिस प्रॉपर्टी पे वो कह रहे हैं कि वो ऑलरेडी उस पर डिमोलिश हो गया था, पूरा हम जॉब कर रहे थे ग्रुप का, और एयरपोर्ट एक्वायर कर दिया था, उस साल वो डिमोलिश हो चुका था।
क्या करेंगे, लगता तो ये छोटा सा मैटर है। आपका कौन है अदर साइड, योर अदर साइड, हु इज योर अदर साइड,
राजीता में
तो चलेगा लड़ाई। बच्चा कितना बड़ा है,
अब तो 11 साल की हो गई।
उसको बुला लेते हैं कोर्ट में, उससे इंटरेक्शन कर लेते हैं।
बुला लिया।
कल उनको आप ये दोनों केस
1.5 साल की बातचीत थी जब ये सूट फाइल हुआ था।
आप इन दोनों केस कर इनका केस परसों कर दीजिए, आपका केस परसों कर दीजिए, ठीक है। कल जो है उनको मैडम को बोल दीजिएगा, चाइल्ड को बुलाएंगे, उसके बाद